Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2, Jefferson County, Texas. My name is Judge Terrence L. Holmes. I'm the presiding judge here in this court. This morning, you were requested to come here because you have a case in this court. The case is set on what we call our arraignment docket. What arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what options you have regarding your case. The case that you have in this court is classified as a misdemeanor case. Criminal cases are divided into either a felony case or a misdemeanor case. The felony cases are commonly referred to as your most serious type offenses, and your misdemeanor cases are normally referred to as petty offenses. Now, that does not mean that they are not serious. For your felony cases, the range of punishment can entail that you be sent to TDC, or Texas Department of Correction, or you could be given a fine up to $10,000. Now, if you have a capital murder case, the punishment is life or death. If you have a first-degree felony case, the range of punishment is 5 to 99 years to life, or fine up to $10,000 and a fine up to $10,000. The range of punishment for a second-degree felony is a minimum of 2 years to a maximum of 20 years, fine up to $10,000. The range of punishment for a third-degree felony is minimum 2 years, maximum 10 years, fine up to $10,000. Or you could have a state jail felony, which means that the range of punishment for a state jail felony is a minimum of 6 months to 2 years in the state jail. Now, for the misdemeanor cases are divided into either Class A, or Class B, or Class C misdemeanor. Your Class C misdemeanors are your cases that's normally in your traffic court, in city court, which is called municipal court, or JP court, which is called the justice court. The range of punishment for that is fine only. You only can be given a fine. You can't be given jail time for a Class C misdemeanor. We handle Class A and B misdemeanors in this court. We only handle C misdemeanors if it's appealed up from the city court or from the JP court. If you have a Class A misdemeanor, the range of punishment is confinement in the county jail from 0 days all the way on up to a year or anywhere in between, a fine from $0 to $4,000 or anywhere in between, or you could be given both such fine and confinement. For a Class B misdemeanor, the range of punishment is 0 days to 6 months, which is 180 days, or anywhere in between, a fine from $0 to $2,000, or anywhere in between, or you could be given both such fine and confinement. Now, the paperwork that's been handed out to you, I will go over that paperwork with you. The first document says judge's explanation of rights to defendants without attorney. As a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number 3, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of this document, it reads, defendant's choice, mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If your choice, well, if you've already hired an attorney, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed counsel, then you'll initial the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you'll put your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign on the line that says defendant, and you will place today's date where it says date, and today's date is July 13th of 2021. Now, for those of you who will be waiving your right to an attorney and representing yourself, you will also have to read and sign the next page, which states, waiver of counsel for purposes of entering a guilty plea or proceeding to trial. And it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 13th day of July 2021 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you will sign on the line where it says defendant, and you will place today's date, July 13th of 2021. Now, as a defendant in a criminal case, you have other rights as well. You have a right to have a trial by jury. And what a trial by jury is where those young people are sitting over there. Brenda, where is she going? Now, you have a right to have a trial by jury. And what a trial by jury is where those young people are sitting. You have a right to have 6 citizens from Jefferson County to be selected as jurors on your case. They will listen to the evidence, and at the close of the case, they will decide whether or not you are guilty or innocent. Now, you have a right to waive your right to have a trial by jury, which means you have a right to give up your right to have a trial by jury. And by doing so, your case will come before the judge or before the court. And either through what we call a trial, which is called a bench trial with a judge only, or if you enter a plea of either guilty or no contest, then your case will come before the judge with the plea, if it's agreed plea or if it's unagreed. An unagreed plea means that you and the state have not been able to work out an agreement. Now, you also have a right to have witnesses to come to court. In essence, you can call witnesses to come to court. They can testify for you, against you, and you have a right to ask them questions. We either call it direct examination or cross-examination. Now, you also have a right to waive your right to have witnesses, which means you have a right to give up your right to have witnesses to testify in your case. And by doing so, you will not be calling any witnesses to testify in your case. However, the state will be calling witnesses to testify. You also have a right against self-incrimination, which means you have a right not to testify in your own case if you desire to do so. However, you can waive, or give up that right to testify if you desire to do so. You also have a right to have discovery. Discovery means you have a right to see the evidence that the state has against you. You have a right to see the documents, the witness statements, videos, DVDs, or whatever evidence that they have against you. You have a right to see that. That's called discovery. Now, you can waive your right to discovery as well. Waiving your right means that you're giving up your right to see the state's evidence that they have against you. Now, you'll have a right as well if you're represented by an attorney or if you're representing yourself, you'll have an opportunity to talk to the prosecutor. Now, and basically what you'll be talking to the prosecutor about is to see if y'all can work out a settlement on your case. The settlement, if you're able to work out a settlement, we call that a plea bargain agreement. If you are able to work out a plea bargain agreement, that's fine. If you're not able to work out a plea bargain agreement, that's fine as well. Now, if you are able to work out a plea bargain agreement and the case comes before the court or the judge does not have to follow that agreement. Now, if the judge does not follow the agreement that you and the district attorney has worked out, then you have a right to withdraw, which means to take back your plea. If the judge does follow the plea bargain agreement, and within 30 days you decide, well, you know what, I think I've been wrongfully convicted. The court committed error by convicting me, and you would like to appeal your case. What an appeal is, you would like to have a higher court to look at your case to see whether or not your case should be overturned. It should be overturned. And so if you decide that you would like to appeal your case, and the court has filed a plea bargain agreement, you have to get permission from the court to appeal your case. Now, if your case is appealed, it will go upstairs to the Ninth Court of Appeals. That's the court that will look at the case to see whether or not your appeal should be granted or denied. If they grant your appeal, then they can find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then within 30 days of them denying your appeal, you will have the right to appeal your case to a higher court than the Ninth Court of Appeals. That court that you will be appealing to is called the Texas Court of Criminal Appeals. It is the highest criminal court in the state of Texas, and you would have to file what is called a pro se petition for discretionary review. Pro se means on your own without the assistance of a lawyer. You'll be asking the Court of Criminal Appeals to determine whether or not your petition should be granted or denied. If they grant your petition, they can find you not guilty, or if they deny your petition, then at that point your conviction will stand. Now, also, if they grant your petition, they can send the case down to this court and order this court to give you a whole new trial. Now, Jefferson County has a program that is called pretrial diversion. It's for people who have not been in trouble before. With the pretrial diversion program, if you get into the program, they dismiss your case and you can get it expunged from your record. Expunged means deleted, wiped off, or erased from your criminal record. Now, in order to get into the program, you can't have a criminal history. This has to be your first case. It cannot be a case involving unlawfully carrying a weapon or resisting arrest. And you have to have the assistance of an attorney to make the application to get you into the program. And as I said earlier, if you get into the program, you complete the program, case is dismissed, you can get it expunged, erased, wiped off, or deleted from your criminal history. Now, Jefferson County also has a program that is called Veterans Court. With the Veterans Court, if you are a veteran of any one of the branches of the United States military, You may qualify for Veterans Court. Veterans Court is part of a pretrial diversion program as well. What happens is you get into the program, Veterans Court, completed, case dismissed, you can get it deleted or erased, wiped off, expunged from your criminal history. Now, this court has a program as well that is called the CSI program. CSI stands for Community Safety Initiative. Community Safety Initiative basically is a program that we have in this court, and we have partnerships with various community agencies. We have a partnership with Spindletop MH&R, and in our CSI program with Spindletop MH&R, they can do private interviews, assessments, and they can develop treatment plans, either outpatient or inpatient, for individuals who have mental health issues. Also, Spindletop has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. Now, the program that they have, we also have a program, well, we also have communications with OZAR, which is the local drug and alcohol council. ATAR is a drug and alcohol counseling program as well. OZAR can do screenings, interviews, and they develop treatment plans, either outpatient or inpatient. And the ATAR program, I think, is for youth, 21 years old or younger, and they can do the same thing. Now, for individuals who do not have jobs or need employment, we have a partnership with Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program. Individuals in the program are trained in either the hotel industry, the chemical industry, these individuals who are trained in the various different programs that they have, they will also assist them at getting a job, okay? Now, the Spindletop program, not Spindletop, but the CICE program that they also have a GED program for individuals who are not, who does not have a high school education. Those individuals are able to get into the GED program over there at Lamar, and they could assist them with getting their education, their high school diploma. Now, these programs that we have, I say, is part of our CSI program. All of these programs are free. It does not cost you anything to get into the program. All thing you have to do is have an interest or desire to be in one of the programs, one or more of the programs. The programs are designed to make Jefferson County a safer place. And the way we can make Jefferson County a safer place is by producing productive people. And these programs are designed to, as I said, to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so if we could produce productive people for the most part do not commit crimes because they have too much to lose. And so when you come to county court at law number 2, we don't have court as usual, we have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before the court. And we're trying to make a difference in our community or in Jefferson County by producing productive people. So we do not just arrest the problem, we address the problem. And so these programs that we have, if you're interested, just let us know. Now, everyone here have been arrested on their case. And then once you get arrested, you get set for arraignment. Now, every day that you spent in jail can be used as credit towards your punishment. So for example, let's say you spent 5 days in jail, and let's say the state has worked out a plea bargain agreement of 5 days. That simply means that you'll be given credit for time served and you will not have to spend any time in jail. Now, if you have more, they offered you more time than that, then we'll just, if they offer you 7 days, that means you have 2 days to do. Now, if you have a fine and court costs, every day that you spent in jail, you get $100 per day. So if you spent 5 days in jail, that's $500. If they offer you a fine and court cost of $500, then you've already spent 5 days in jail. Then you will not have to pay anything. Why? Because the time that you spent in jail has already paid it off. Therefore, it will be taxed and retired. Now, if you owe more than that, then they can, if it's $700 and you've already been 5 days, that means you'll have to pay $200. Now, the other thing is this: if you have a fine that you've been ordered to pay and you cannot pay the fine that day, then we could put you on what is called a payment plan, where you could pay it in installments. But let's say you don't have the money, you can't pay it at all, then what we can do is convert your fine to community service. And so you can work off the fine and court costs. Every hour of community service you do is credited at $12.50. So if you work an 8-hour day, that's $100 per day. Now, if you have now with the fine and court costs, if you cannot pay it off, you cannot work it off, then there are other things that the court has that the law gives the judge authority to do. Now, with regards to the programs that I spoke of earlier, all of those programs can be used as community service. The program with Spindletop, the program with ATOR, the drug and alcohol programs could be used as community service. GED program could be used as community service. The job training and job placement programs could be used as community service. So that simply means that, for example, if you are getting mental health treatment, every hour you spent there goes $12.50 toward your fine and court costs, and 1 hour toward your community service. Or if you're in a GED program, the same thing. Or if you're in a job training program, every hour you being trained, 1 hour is going to community service, and $12.50 is going to your fine and court costs. So you're killing 3 birds with 1 stone. What I mean by that is, you're in the program, you're paying your fine and court costs, and you're doing community service. You're doing one thing, but you're getting credit for 3. Okay, and so that's, if you're interested in any of those programs, just let the court know, and then we can provide you with information that can assist you with getting into any one of the programs. Now, we have individuals here who is from Spindletop, and is Deputy Hinton going to speak to him this morning? Okay. Okay, so we're going to have one of the representatives from Spindletop to come forward, and they're going to speak to you about the programs that Spindletop have.
Thank you, Judge.
Okay.
Good morning, everybody. My name is Shelby. I'm a mental health professional with Spindletop. So, like Judge Holmes said, we're here to talk to y'all. If anybody wants to come back and talk to us about maybe some mental health concerns, it doesn't have to be for yourself. It could be for family. It could be for friends. Along with that, we do substance use treatment. So if that's something you're interested in getting more information about, we can talk about that also. In a little while, my colleague and I are going to come around and get some information from y'all, and we'll also leave you with a pamphlet. Yeah, if you just have any questions, we're here to talk, and we can help.
Okay, thank you. Now, ladies and gentlemen, what we're going to do, that paperwork that's been handed out, this is going to be picked up. We're going to have someone from our court staff to pick the information up from you, and just going to have to take a few minutes. We're going to put you into different categories, and then once we do that, then we'll be able to proceed. So this is going to take a little time, and so just be a little bit patient with us at this time, okay?